Did Justice Brown Jackson actually reveal the outcome of that major case of Loper Bright, which is going to dictate whether or not the Chevron doctrine is going to be tossed aside for all eternity, and thus cutting back dramatically on the powers of federal agencies such as, indeed, the ATF? You're not going to want to miss what a professor at Case Western uncovered with an oral argument involving Justice Brown Jackson just recently. Shocking information. Wait till you hear it when we get right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of many books, including Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. Stay tuned for a big announcement coming up about the next book very soon. All right, folks, as you know, one of the critical things we in the Second Amendment and the Freedom Movement want to win this Supreme Court term is we want the Loper Bright case to issue a ruling that says that the Chevron deference doctrine that says that courts are supposed to defer to the interpretations of administrative regulations and statutory rules and the like when it involves a case that one of the parties is an administrative agency. In other words, the Loper Bright Supreme Court case this term is asking the question whether or not the Chevron doctrine should be undone. The Chevron doctrine says that if there's ambiguity or questions about what a statutory authority given to an agency such as the ATF, whether there's ambiguity or what it means, courts should defer. Courts should defer to the interpretation of the administrative agency, which is a terrible rule of law because what you're really saying is that courts should defer to the interpretation of a statutory rule or regulation as interpreted by one of the parties to the case, i.e. that regulatory agency. So if you're an FFL or an American gun owner in litigation against the ATF, for example, and the ATF says we think the rule means X, courts are generally speaking supposed to defer to that interpretation of X by the ATF on the grounds that they are the subject matter experts. That's essentially what the Chevron doctrine means. The Chevron doctrine came out of a case involving Chevron many decades ago, but the question is whether or not that should remain good law. We want that to be knocked out of the park and goodbye, gone forever. We want the Chevron deference rule to go away. So the question is, and the breaking news here, is whether or not Justice Brown Jackson, during an oral argument in a case involving, believe it or not, interchange fees associated with debit card transactions, which involves regulatory agencies and regulatory organizations like the Board of the Federal Reserve System and some of these others. There was a big lawsuit over these credit card, debit card exchange fees. I won't bore you with the details, but in the context of this colloquy back and forth during oral argument in the middle of this case, the following occurred. You're not going to want to miss this. Listen to what Justice Brown Jackson says when she's asking questions of one of the lawyers about whether or not allowing more and more lawsuits by a private party might cause a disruption to the court system. Listen very carefully to what she says about Chevron. I think you're not going to want to miss it right here, right now.
But why wouldn't this be extraordinarily destabilizing in the way that Justice Sotomayor suggested? I mean, we have settled rules that govern all sorts of industries, the healthcare industry, the finance industry, and people have adjusted themselves around them. They're experts who understand how the law works, and companies follow suit. If I understand you correctly, each new company that is created in an industry can suddenly bring a challenge that might risk or undermine invalidation of the entire basis of the industry. Each new company, because you say each new company that's created can bring such a lawsuit. Now, whether or not it will succeed, I understand, but aren't you risking destabilization of the industry in this way?
We don't think so. We think the experience in the Sixth Circuit is what you'll see. There was no uptick in challenges to old regulations in the Sixth Circuit, and we would have seen them there.
Is that possible because we had other doctrines that prevented? So, for example, Chevron existed, and so there were lots of things that already, right? Like, there are reasons why you might not have an uptick. I'm just wondering, in a world in which you could bring these actions, why wouldn't you have this problem?
Well, that certainly sounds like Justice Brown Jackson is acknowledging that the Chevron doctrine is no longer the doctrine, but the Loper-Bright case has not been decided. By the way, we must give a hat tip to a professor of law at Case Western University, Jonathan Adler, who does a great job on a lot of different topics, but he's a very strong writer and a very articulate guy who writes for the Volokh Conspiracy. I've recommended the Volokh Conspiracy website to you before, especially if you're a law clerk or you're a lawyer involved in high-level constitutional or Supreme Court litigation. The Volokh Conspiracy is very good source for tracking some of that information. You may want to check it out. And Jonathan Adler flagged this exact issue in a recent issue of a post of his on the Volokh Conspiracy, and I'm giving a hat tip for him identifying this, and I listened to the recording myself, and I think that's right. Justice Brown Jackson is basically acknowledging that at the end of this term, the Chevron doctrine is going to be no more, which is good news for the Second Amendment community. By the way, I should note that, remember I've always told you that on the three liberals of Justice Sotomayor, Justice Brown Jackson, and Justice Kagan, Justice Elena Kagan, who's the former dean of the Harvard Law School, is the cagiest, the sharpest, the most savvy, and the one that's the most dangerous to our rights, because I think she's sharper and a little bit more politically savvy than the other justices on the left. Listen to how Justice Kagan caught what Justice Brown Jackson said and tried to save the day by suggesting it was kind of a hypothetical game. Listen to what Justice Kagan says to try to save the face, if you will, of Justice Brown Jackson during this slip-up in this case of Corner Post versus the Board of Governors of the Federal Reserve System. Here's Justice Kagan right now.
Mr. Sider, I want to emphasize that I'm asking you a hypothetical question. It's a if question. There is obviously another big challenge to the way courts review agency action before this court. Has the Justice Department and the agencies considered whether there's any interaction between these two challenges? And again, if Chevron were reinforced, were affirmed, if Chevron were reversed, how does that affect what you're talking about here?
So really kind of shocking information, but because I try to make you the smartest person in the room, and sometimes you catch things involving our Second Amendment rights that are not obvious. And here's an example of it, where it certainly seems to me, and this is good news, that Justice Brown Jackson has disclosed that the Chevron doctrine is bye-bye, which is exactly what we in the Second Amendment community want, and it's exactly what the ATF does not want, because the ATF wants to be able to write letters, nasty letters to FFLs and to American gun owners, and cite the Chevron and say, our interpretation goes, we win because we're the ATF and we have the Chevron doctrine. But once the Chevron doctrine goes away, the ATF is not going to be able to have that leverage over gun owners and the Second Amendment community and FFLs going forward. And that is a good news. So hopefully this slip of the tongue of Justice Brown Jackson is not a slip of the tongue. It is simply declaring the fact that the Chevron doctrine is going to be dumped into the dustbin of history. That will be very good for freedom and very bad for deep state, and it certainly will be bad in many ways for, among others, the ATF, which is good for freedom and the Second Amendment movement in America. So there you have it. We'll see what happens, but interesting news. Good job, Professor Adler, for flagging this for all of us. And don't forget to follow me on X at 4 Boxes Diner, and we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.